you very much. Thank you all for attending this evening on screen and in person. It's been difficult, I'm sure, for many of us to avoid the debate that in recent years has taken and is taking place around gender critical beliefs about trans women. It's particularly difficult to avoid if you are a user of the sometimes toxic and nearly always, in my view, flatulent echo chamber that is Twitter. Over the last few years, there have been a number of Employment Tribunal and EAT decisions which have addressed parts of this issue. And this year, the topic has really lapped at our shores with a case which was not only about the treatment of a gender-critical woman who forcefully expressed her views, but she was a barrister, and the respondents included all of her fellow members of chambers. And that's one of the cases that we will be discussing this evening. I think it's probably fair to say that the story doesn't end here, but there's already a demand for advice from both employers as to how to deal with situations in the workplace akin to those in some of the case law, and from employees, either trans or those expressing gender critical views, or those who find the expression of such views to have been in a manner that crosses a line as to what they feel is acceptable in a workplace that they're willing to belong to. What we hope to do this evening is to outline the recent case law and focus on the practical consequences in the workplace. My fellow member of Chambers, Naomi Cunningham, has been involved in some of the litigation surrounding this topic, including the challenge to the lawfulness of the EHRC's Code of Practice in AEA and EHRC. And she has an encyclopedic knowledge of the relevant case law and the underlying statutory provisions. And I'm going to turn over to her now briefly for her part in this introduction, and I'm going to show you a picture which she's asked me to show you.
My part of this talk is called Elephants and Elephant Traps, and I just wanted to pop up briefly before Andrew gets stuck into the substantive law that he's going to outline, to acknowledge the elephant in the room and let it amble off. The elephant in the room is, as probably everybody here knows, certainly most people know, that I broadly share the beliefs that lost Maya Forstater her position with CGD, namely that biological sex is real, it's important, it's immutable, and it's not to be conflated with gender identity. They're different things. We're not, of course, going to, and that's the last thing I will say on the substance of that belief. We're not here to discuss the substance. But inevitably, the position that I take is going to affect the way that I talk about the law in this area. Staying with the elephant theme, the question I want to address, the overarching question I want to address is what are the main elephant traps for employers and employees in this area, and how do they avoid them? How do you keep them out of them? There have been 5 cases in the Employment Tribunal and EAT over the last couple of years that between them provide quite a helpful illustration of some of these traps. But before we get onto those, I will hand back to Andrew to set the scene.
Thank you, Naomi. I'm going to run through the main principles and outline those 5 decisions that we will address. And I'll also mention along the way some additional traps, elephantine or otherwise, that have occurred to me as I've trawled through the legislation and the case law. We have to start, I'm afraid, with some black letter law, and I'm going to share it with you on the screen. Those of you very familiar with it will have to forgive me for the whistle-stop tour. We're going to start with Section 9 of the Gender Recognition Act 2004, and in particular Section 9.1, where a full gender recognition certificate is issued to a person, the person's gender becomes for all purposes the acquired gender. Now that interacts with Section 7 of the Equality Act, which is where we have the definition of the protected characteristic of gender reassignment. A person has the protected characteristic of gender reassignment if the person is proposing to undergo, is undergoing, or has undergone a process or part of a process for the purpose of reassigning the person's sex by changing physiological or other attributes of sex. Now, there are exceptions to the way in which this protected characteristic operates. There are exceptions in respect of service provision set out in paragraph 28 of Schedule 3 of the Equality Act. And there are the usual exceptions in relation to occupational requirements in Schedule 9. But just taking these two pieces of legislation together, there are all sorts of problems with this legislative framework. The 2004 Act requires a person to be diagnosed with gender dysphoria in order to apply for legal recognition of their gender, which some trans people find offensive. The Equality Act doesn't expressly tell us what the process is that's referred to in Section 7. But it's tolerably clear, at least to me, that the process is the process referred to in the Gender Recognition Act. And that would appear to exclude quite a large number of trans people who are not proposing to go through any such process, and exclude them from the protection of that part of the Equality Act. Both pieces of legislation also have terminology problems. They refer to transsexuals. Trans people these days often prefer the use of the term trans or transgender as opposed to transsexual, but that's the word used in the legislation. Of course, some trans people prefer simply to use the terms men or women. Gender and sex are used in both pieces of legislation without, I suspect, a great deal of thought having been given at the time as to whether they are the same thing, overlapping, or completely separate concepts. Behind the factual matrix of some of the cases we discuss are proposed changes to the gender recognition legislation, permitting self-expression of gender identity to form the basis for protection, which in some cases is the topic, discussion of which has given rise to the forceful exchanges of views in the workplace, which have then given rise to some of the litigation that we've seen. The protected characteristic of belief is defined in Section 10 of the Equality Act. And in particular, at Section 10.2, belief means any religious or philosophical belief, and a reference to belief includes a reference to a lack of belief. The leading case as to whether a belief qualifies for protection is Granger and Nicholson, where there are 5 criteria set out. And it's the 4th and 5th Granger criteria which are most relevant for our analysis this evening. A belief must attain a certain level of cogency, seriousness, cohesion, and importance, and must be worthy of respect in a democratic society, not be incompatible with human dignity, and not conflict with the fundamental rights of others. The EHRC Code of Practice adopts the Granger criteria. Section 3 of the Human Rights Act 1998 requires courts and tribunals to read and give effect to statutory provisions in a way which is compatible with the rights conferred within the European Convention. Article 9 of the Convention sets out the right to freedom of thought. And at Article 9, subsection 2, we can see that freedom to manifest one's religion or beliefs shall be subject only to such limitations as are prescribed by law, necessary in a democratic society in the interests of public safety, for the protection of public order, health, or morals, or the protection of the rights and freedom of others. The right to a manifestation of philosophical beliefs can often overlap with freedom of expression, and Article 10 may come into play. And there is a similar restrictive definition of limitations which can be placed on freedom of expression. The protected characteristic of sex is defined in Section 11 of the Equality Act, which will be familiar to all of us. And that can leave us in no doubt that this section refers to sex and not gender, and no doubt that it is binary in relation to the definition. However, many recently drafted internal equal opportunities policies that I've come across now refer to gender rather than sex in the list of protected characteristics. Now, whatever the rights and wrongs of the debate, and I think it's open to any organisation to add gender to its equal opportunities policy, which should already have gender reassignment, as one of the characteristics on the list, I would advise against changing the word sex to the word gender, because that doesn't reflect the wording of the legislation, and it leaves an organisation open to the accusation that it is attempting to erase sex, for example. Now, the protected characteristic of sex in Section 11 includes protection of trans women with a gender recognition certificate, where the detriment is, for example, because of sex or related to sex, although it does not, it seems to me, protect trans women without a gender recognition certificate in those situations. Also worth touching upon, although it's not our focus today, people identifying as gender fluid or non-binary do not easily fit into any of the categories of protection outlined thus far, unless they might be said to have a belief of such, of some nature. Other relevant parts of the European Convention, which might provide some possible support for claimants who are non-binary or gender fluid, may be Article 8, right to respect for private life, and also in terms of competing human rights arguments, Article 17, prohibition of abuse of rights, may come into play, and that was of particular importance in the Forstater EAT case. Now, turning to the 5 cases which we're going to look at in a bit more detail, these are fascinating cases, but a word of warning. Many of the decisions that we will be talking about are first instance decisions. The only one of the 5 of them that I think is a really notable binding authority is Forstater in the Employment Appeal Tribunal. And we'll start with Forstater. In brief outline, in this claim for direct discrimination because of gender critical beliefs and harassment relating to gender critical beliefs, which was presented to the tribunal in 2019, the claim was knocked out at a preliminary hearing on the basis that the claimant's belief that biological sex is real, important, immutable, and not to be conflated with gender identity was held to be not worthy of respect in a democratic society. That decision was overturned at the EAT in June 2021, when the then President, Mr. Justice Chowdhury, and 2 lay members held that the claimant's belief as to the immutability of sex amounted to a philosophical belief under Section 10. And then in July 2022, the ET, at a full hearing, held that CJD's decision not to renew Ms. Forstater's contract and not to renew her visiting fellowship had been because of her protected belief and was therefore unlawful direct discrimination, and that her removal from their website had been an act of victimization. A number of other claims of victimization, harassment, and indirect discrimination were dismissed. At the PH, the employment judge had in fact raised with the parties the question of whether it was appropriate to proceed with that argument at a preliminary hearing, and the respondent agreed that it should be dealt with at the full hearing, but the claimant wanted to press ahead. Top tip there is to maybe take the hint if the employment judge is suggesting not going ahead with a particular issue. The primary basis for the finding at the preliminary hearing appears to have been that the claimant's views in their absolutist nature went too far, in that she went so far as to deny the right of a person with a gender recognition certificate to be the sex to which they had transitioned. Her view, the Forstater view, therefore not reflecting the statutory position. Forstater in the EAT boiled down to the application of the 5th Granger criterion and Article 17 of the ECHR. The appeal tribunal concluding that only if the belief involves a very grave violation of the rights of others, tantamount to the destruction of those rights, would it be one that wasn't worthy of respect in a democratic society. Beliefs that are offensive, shocking, or even disturbing to others, and which fall into the less grave forms of hate speech, would not be excluded from the protection. However, the manifestation of such beliefs may, depending on the circumstances, justifiably be restricted under Article 9.2 or Article 10.2, as the case may be. The EAT did, however, make some pointed remarks about the limits of protection afforded to such a belief, and in particular made reference to misgendering and the possibility that it could amount to harassment in certain circumstances. The EAT also made it clear that the belief that everyone has a gender which may be different to their sex at birth, and which effectively trumps sex, so that trans men are men and trans women are women, the gender identity belief, is also a philosophical belief qualifying for protection under Section 10, as was not sharing that belief, given the way that Section 10 is defined. The Employment Tribunal then, on the 6th of July 2022, found for Ms. Forstater, in part, on her claim. The second case that I'm going to look at is that of McCareth and the DWP. In that case, in June 2022, the EAT upheld a tribunal's decision that the DWP's treatment of a medical assessor who refused to use the preferred pronouns of service users was not discriminatory. The tribunal had found that whilst the claimant's Christian belief in general was protected, his specific belief or lack of belief that a person cannot change their sex or gender at will was not protected on the basis of several of the Granger criteria. Now, the EAT went through this in great detail and found that this was largely an error of law in its application of the Granger criteria by the Employment Tribunal, albeit that the tribunal was entitled to find that the claimant had not satisfied the Granger number 4 criteria, which, reminding ourselves, is cogency, seriousness, cohesion, and importance, in relation to some parts of the claimant's asserted beliefs when taken in isolation, those beliefs having been asserted to be a lack of belief in some aspects of transgenderism, which the claimant said amounted to a lack of belief in something articulated by him that, in fact, didn't actually reflect any alternative philosophical position, namely that he didn't believe that impersonating the opposite sex may be beneficial for an individual's welfare, and he didn't believe that society should accommodate anyone's impersonation of the opposite sex. However, the tribunal had actually gone on sensibly to find that even if Mr. McCareth did have a protected belief, that he hadn't actually been discriminated against in any event. And so that part of the decision was upheld at the EAT, and the appeal ultimately failed. One thing that we might take from McCareth is that there may not be protection of a belief if it is articulated as a lack of belief in something that no one is actually asserting. Bailey and Stonewall and Garden Court Chambers is the next of our 5 cases. Bailey is a case brought by barrister Alison Bailey against her Chambers and Stonewall for belief discrimination. She won part of her claim against her Chambers, lost other parts, and she lost all of the claim against Stonewall. All 3 parties promptly claimed a famous victory. So this seems to have been that real rarity in litigation, an outcome with which all parties were pleased. The 105-page judgment and reasons, dated the 27th of July of this year, sets out over 400 paragraphs the decision of the full tribunal chaired by Employment Judge Goodman. It is an erudite text. It's well worth a read. It's the first time that I've seen reference to the Whore of Babylon since leaving Northern Ireland in 1989, where little else was discussed during my childhood. It contains the only reference to Milton's Areopagitica that I am aware of in any employment tribunal judgment. And in one paragraph, paragraph 42, for those of you who want the short read, the tribunal gives a very nice summary of term 1 of a gender studies course, including references to Mary Wollstonecraft, John Stuart Mill, Simone de Beauvoir's famous expression that one is not born, but rather becomes a woman, and Judith Butler's infamously impenetrable works, in which she explores the performativity of gender. I also enjoyed the acidic comments about the randomly thrown together 6,000-page bundle. And my favourite remark in the reasons is at paragraph 101. The clerks themselves seem to have had little knowledge of or interest in the gender-critical/gender self-identification debate. Most conversation was about football. The tribunal also correctly makes reference to the continuing history of male violence towards women and the open abuse and sometimes violence that trans women are subjected to. The claimant's asserted beliefs, associated with the core belief that a woman is defined by her sex, not her gender, were all determined to be protected. The tribunal was careful to point out that this was not to say that the claimant was right in relation to all of her beliefs, and also pointed out that trans women can also need safe spaces because they too can be subject to violence, and that there may be an element of moral panic about trans women who are not convicted sex offenders being offered places in women's prisons. The tribunal stated in paragraph 53, both the belief that women are defined by sex and the belief that gender is a matter of self-identity are protected as beliefs. Toleration of difference is an essential characteristic of an open, pluralistic society. The tribunal found that the publishing of a statement by Chambers stating that the claimant was under investigation and the upholding of a complaint about the claimant were direct belief discrimination, and that the second of those was also victimization. The complaint that Chambers had caused a decline in the work allocated to the claimant was rejected, as were a number of indirect discrimination claims. And as I've said, all of the claims against Stonewall alleging instructing, causing, or inducing discrimination were all rejected. The claimant was awarded £22,000 plus interest for compensation for injury to feelings, which will have been completely eclipsed by the legal costs many times over. The against Sheffield Teaching Hospitals is another first instance decision. This one's dated the 1st of July 2022, and a tribunal upheld a trans claimant's complaint that questioning her about her habits in relation to wearing underwear at work was direct discrimination on grounds of gender reassignment. A host of other claims, including those against 6 named individual respondents, failed. That claimant was a catering assistant. She had been the subject of historical transphobic abuse. And as someone who was in the process of transitioning, there was an agreement that she use a toilet cubicle in the women's changing room at work. A concern about her state of an undress in the changing room was raised, and the claimant was specifically questioned about her wearing of underwear at work. The tribunal considered that this was likely to be connected with the fact that she is a transgender woman, in that it didn't seem to the tribunal likely that there would have been a concern about a cisgender woman in a state of undress while changing in such a changing room. The burden of proof therefore passed to the respondent to show that its actions were in no way discriminatory, which it failed to do. One takeaway from this judgment for employers is certainly always to have a good non-discriminatory reason for their actions in relation to each and every one of the allegations made against it. The final case is that of Taylor and Jaguar Land Rover. That's a 2020 Employment Tribunal first instance case, in which the tribunal found a number of complaints of harassment related to gender reassignment and direct discrimination because of gender reassignment and victimization were made out. The claimant was an infotainment simulation and architecture engineer who'd worked for the respondent since 1998. She had informed the respondent in about 2017 that she was transitioning. And in her case, she regarded herself, she stated, as gender fluid, which she said could be part of the transgender journey that she was on, but not necessarily the final destination. She had no plans for any surgical transition. It was accepted by the respondent's witnesses at the tribunal that the claimant was subject to harassment related to gender reassignment over a sustained and prolonged period of time. The claimant hadn't brought any individual complaints internally naming names, but had brought the behaviour to the attention of her employer. The respondent had a dignity at work policy somewhere in a drawer, but none of the managers who gave evidence had actually been trained on it. The claimant was required to use the disabled toilets, and she was repeatedly verbally abused. Notably, she was given little or no support, and action was not taken against those who had abused her, and no more generic action was taken to diffuse the situation, save to advise her to be less sensitive. The obvious lesson here for employers is not to let things lie, and not to consider that there is no obligation to take any action in the workplace if there is no specific complaint naming names. Now, having given you that introduction, Naomi is going to address you on some of the elephant traps that can befall clients in these circumstances.
All beliefs that pass the 5 Granger tests are of equal standing. So employers are entitled not to ask their employees to proselytise at work and can place some restrictions on what they say, but they need to place equal restrictions on what they say, and exactly how far they can restrict their employee's speech will depend on all the circumstances, like how senior the employee is, what the nature of her role is, how obviously connected to the employer she is, and so on. So judges and civil service servants can be expected to keep pretty silent on matters of public controversy. Supermarket checkout staff, not so much, because no one expects them to be speaking for their organisations. There's been quite a lot of comment on Forstater to the effect that CGD's difficulties, the difficulties that CGD got themselves into, could have been avoided if only they'd had a properly robust social media policy in place. There are 2 problems with that. The first problem is that Maya Forstater's social media engagement, or her public engagement with this debate, although it was direct, it was pretty measured. That means that any social media policy that was sufficiently restrictive to silence her would have needed to be pretty draconian across the board. If it had singled out gender critical engagement for prohibition, that would have been discrimination just the same. You can't, of course, make discrimination not discrimination by making it your policy to discriminate and then saying, oh, we didn't discriminate on the prohibited ground, we just acted in accordance with our policy. That doesn't work. You can't make discrimination disappear so easily. It'd be too easy for employers if you could. So an employer could, in theory, decide on the draconian route and treat everyone equally, and just purport to put all political or contentious social media engagement right out of bounds. But think a bit about the practicalities of trying to enforce such draconian policy. It's going to have a high cost in both management time and industrial relations. People aren't going to like being silenced to that extent. And bear in mind that, for instance, statements like trans women are women are going to be silenced. And that's the sort of thing that people say a great deal on social media. So those are going to be silenced along with gender critical utterances. So it's going to have a high cost. It's also, if dismissal arises as a result of breach of such a policy, employers are likely to find it quite difficult to defend as consistent with the employee's Article 10 right to freedom of expression, which will of course be part of all the circumstances that a tribunal has to consider when ruling on the fairness of dismissal. On the other hand, if an employer writes a draconian policy but only enforces it reactively when somebody complains, well, the problem with that too should be obvious. Effectively, you'd be letting the mob decide which opinions may be expressed and which may not. And again, if the mob discriminates, you discriminate. So again, it's another way you can't just make discrimination disappear. A related elephant trap is a less draconian, neutral-looking policy. Suppose your policy says something like this: you must not make any social media communication that could damage our business interests. That looks even-handed and pretty light touch. And it may be fine, but if what this formula really means is that employees mustn't express unfashionable views because third parties might object and might make trouble, that too won't preserve them from a finding of discrimination if they enforce in that manner. A more familiar parallel may help make this vivid. an airline can't get away with saying, well, of course, we know that women make perfectly good pilots, but we don't employ women to fly our planes because passengers wouldn't feel safe and they vote with their feet. Once again, as with mob rule, you can't pass discrimination down the line like that. So what do I say a social media policy, a sensible social media policy should look like? I'd suggest that for most organisations, it will simply ask senior and middle ranking employees to make it clear that the views that they express are their own and to express themselves lawfully and reasonably courteously in any event. There's nothing conceptually difficult about that. Although an organisation faced with a social media pile-on may be called upon from time to time to hold its nerve. But if you think about the difficulties that CGD got into, you might think that the outcome for them would have been a great deal better if they had indeed held their nerve instead of panicking. And that takes me directly to my next elephant trap, which is running scared. This, in my view, was quite clearly illustrated by CGDs or the conduct of CGD managers after my Forstater started to engage in debate about the proposal to reform the Gender Recognition Act to bring in self-ID. It's notable from the evidence quoted in the judgment that some managers were initially quite nonplussed. They didn't know where this had come from. What's this all about? One even admitted at an early stage that he wasn't sure whether or not he agreed with Maya Forstater. But as the campaign against her intensified and they became aware of internal reactions to her tweeting, described by one witness to the tribunal as visceral, they fell into line. Their problem seems to have been a disinclination to look behind claims to be offended by Ms. Forstater's tweets and make up their own minds whether she'd said anything genuinely unacceptable, which of course was their duty as managers. The high watermark of the evidence against her seemed to be that she had described a man known sometimes as Philip Bunce and sometimes as Pitt Bunce as a part-time cross-dresser in the context of a discussion about whether he should have accepted an award for women in business. That's Pitt or Philip Bunce. Cross-dresser is a term that can be found in many LGBTQ plus organisations' glossaries, and Bunce is a man who sometimes, but not always, cross-dresses at work. So for my part, I find it quite difficult to see what was wrong with Forstater's description. It seems flatly factual. That's not to say that it was completely fanciful to think that her phrase was a bit rude. It was certainly used in the course of a fairly irritable exchange. She was criticising this man for having accepted an award for one of the top 100 women in business. But the tribunal itself was split about whether it was a bit rude. Employment Judge Glennie and Mr. Miller taking the view that it was uncomplimentary and dismissive, but not in all circumstances inappropriate or objectionable. The third member of the tribunal, Ms. Carpenter, did think it objectionable, although that didn't affect Ms. Carpenter's view of the resulting case. I would suggest that sensible managers faced with the complaints against Maya Forstater would have given them short shrift. Employees are not entitled to demand that their employers protect them from having to work with people they disagree with, or even with people who are sometimes a bit rude about third parties on social media. And they shouldn't be encouraged to think that they are. That leads to my next elephant trap, which is bring your whole self to work. It's become fashionable for HR policies to talk about making everybody feel psychologically safe and able to bring their whole selves to work. This may be some of the worst advice ever given to employees. None of us should bring our whole selves to work. This is a man who did. This is a teacher in a classroom, in a Canadian classroom, who brought his whole self to work because he identifies as a furry. And his school didn't feel able to tell him to go home and come back properly dressed for work because identity. That's Canada, it's another country, things are very mad there. But seriously, none of us should bring our whole selves to work. It's perfectly fine to be an enthusiastic amateur opera singer or jiu-jitsu practitioner or free climber in your own time. But if you sing opera, wrestle your manager, or actually literally climb the walls in staff meeting, it's not going to go well. Mr. Pay, the claimant in Pay and Lancashire Probation Service, was dismissed because of what he did in his own time. If Mr. Pay had brought his whole self to work, it wouldn't have taken the whole intellectual heft of the Court of Appeal to spot that dismissal was fair. If you can't remember what Mr. Pay was dismissed for, you can use that as an icebreaker over drinks. But more seriously, this kind of messaging is calculated to lead employees to expect to be able to police their colleagues' beliefs and opinions. And that's just not going to work in a diverse society or a diverse workplace. My Forstater's belief that the differences between male and female bodies sometimes matter does seem to have been bitterly offensive to some of her colleagues. But no doubt the opposing belief that men can be lesbians and women and girls are not entitled to any reliable privacy from men was bitterly offensive to her. You can play the same game with many irreconcilable beliefs. An ethical vegetarian may think I'm little better than a murderer because I eat meat. A religious colleague may think I'm destined for hell because I don't believe in God. Or an environmentalist may think I'm a vandal because I drive a car. That's all fine, or it should be. Some of these clashes of belief may make friendship difficult, but they shouldn't impede working together, so long as everyone respects everyone else's freedom of belief, conscience, and speech. So the message here for employers is don't write policies that give employees the impression that they can expect their colleagues to share their beliefs, or even that they can expect their colleagues to pay lip service to their beliefs. But do make sure that employees don't proselytise to the point of nuisance in the workplace or try to impose their beliefs on others. It's one of those rules that's fairly simple to state. No doubt there will be cases where it's difficult to apply in practice. Of course, elephant traps aren't just there for employers. My next one is for employees, and it's being a martyr. I think that's St. Sebastian. Dr. Macareth, as Andrew related earlier on, was the medical assessor employed by the DWP. It does seem, from reading the judgment, that the DWP had made considerable efforts to explore with Dr. I think Macareth actually, but if anybody knows for sure, please correct me. It does seem that the DWP had sought to explore with Dr. Macareth the parameters of his position, and had at least some inclination to retain his services if they could. But Dr. Macareth resigned, saying that he believed he was being dismissed while that process was ongoing. The Employment Appeal Tribunal confirmed that the tribunal had permissibly found that the DWP's conduct had been a response not to Dr. Macareth's beliefs, but to the way in which he'd indicated that he was determined to manifest them. Dr. Macareth seems to have jumped early on in the process to the conclusion that he was bound to be dismissed and to have been unwilling to engage constructively with DWP's attempts to find accommodation. It's not obvious that that was necessarily a lost cause. Dr. Macareth was willing to use clients' preferred names, and in one-to-one meetings, you might think it wouldn't be all that difficult simply to swerve the problem of using pronouns at all. So I'd suggest that if you're advising an employee in one of these situations, and these situations are still blowing up with great regularity, as an aside, that there is a lot of anecdotal evidence that the Forstater memo has simply not landed with a very large number of employees. So these sorts of situations are blowing up on a regular basis. If you're advising an employee at an early stage of one of these disputes, I would suggest that the key lessons from Macareth are fourfold. First of all, stay calm and assume that your employer is acting in good faith until the evidence to the contrary is overwhelming. Secondly, don't force matters to a head if you can help it. Be open to pragmatic workarounds that respect others' conscience and belief as well as your own. Now, when your own deeply held conviction impinges on how you do your work, you do have to be able to perform quite an advanced manoeuvre. That's the move that goes like this. You need to be able to say, although on the substance of this, I know that I'm right, and I believe that the contrary view is some combination of mad and wicked. Nevertheless, What actually happens next in this particular workplace situation is somebody else's call. That's quite a tricky thing to do, but it's a crucial thing for employees to be able to do when they're faced with these situations at work, if a reasonable working peace is to be kept. Third point from McCareth is decide on your own red lines and communicate them clearly. But crucially, don't jump before you're pushed. If someone is going to decide, if someone in this workplace is going to decide that it's impossible for you to retain your employment because of your beliefs, don't make it you, make it your employer. So don't fail, hold still, state your position, and let the employer make the decision. Then you will be in a much better position if it comes to bringing an employment tribunal claim. My final elephant trap is confusion. And that's the best I could do for a slide about confusion. Confusing the right not to suffer gender recognition discrimination with the right to be treated for all purposes as the opposite sex. And this is a very widespread confusion. The case I want to use to illustrate this is V and Sheffield Teaching Hospitals. It's first instance employment tribunal decision, so of course it has no value as precedent. And in any case, in at least one respect, which I'll come to, it is in my view pretty obviously wrong. But it's certainly, no, it's, sorry, I was confusing two cases. In the only respect in which the claim succeeded, I think it's pretty obviously wrong. But it serves anyway as a cautionary tale. V was a transidentical, V is a transidentifying man. He applied for a job as a catering assistant. He was given permission to use the women's toilets and changing and showering facilities from the start of his employment. And his female colleagues were told that that was what he would be doing. They were also given training before V started work that seems to have been designed to ensure that they didn't raise objections, that they didn't feel able to raise objections. The judgment of the employment tribunal is silent as to what, if any, medical treatment V had undertaken. But in any event, it's very clear from the way the facts developed that he was obviously male. V resigned a little over a year after he started work and made a number of complaints against the hospital, including complaints of gender reassignment discrimination. Only one of his complaints succeeded. The tribunal clearly had serious doubts about his truthfulness. But that one arose as follows. In June 2021, there was a report to a manager that V had been seen naked from the waist down in the women's changing room. On a previous occasion, he remarked to a colleague that he was hot and sweating and had taken his underwear off, making a wringing motion with his hands. A manager asked him in a meeting about whether he was in the habit of removing his underwear, and the tribunal found that that question was asked because of his gender reassignment and was to his detriment. He therefore succeeded to that extent in his complaint of discrimination. All his other complaints were dismissed. The tribunal approached his complaint of discrimination on the basis that if he hadn't been a transsexual, he wouldn't have been asked whether he was in the habit of removing his underwear. The comparator used by the tribunal is what it calls, what the tribunal calls a cisgender woman in a similar state of undress. If V had had a gender recognition certificate, there would be a respectable argument, at least, that a woman would be the correct comparator. Although I think, after a lot of anxious thought about this subject and a long detailed argument, I do now think that the better view is that even so, the correct comparator is a man who is not trans. But there's no suggestion in the judgment that V had a GRC. And on the assumptions he didn't, the tribunal certainly chose the wrong comparator. If you want to know whether V was asked the question because of his trans status, you need to think how the employer would have treated a man who was not trans, who was seen naked from the waist down in the women's changing room. And the answer is obvious, he would have been dismissed. Certainly would have been disciplined, but I would have thought he would have been dismissed. I think the same error underpins the hospital's approach to V's use of women's facilities in the first place. It seems to have assumed that to deny him the right to do so would have been discrimination on grounds of gender reassignment and unlawful. But it would have been neither of those things, in my view. If he'd been excluded like any other man, that would have been because he was trans. That would have been not because he was trans, but because he was a man. It wouldn't have been sex discrimination because there were equivalent facilities for men. And it couldn't have been unlawful indirect discrimination on grounds of gender reassignment, because it was so obviously justified in the interests of protecting the privacy and dignity of female colleagues and complying with the obligations under the Workplace Health, Safety and Welfare Regulations 1992 to provide separate facilities for men and women. So in my view, and there's a wrinkle in this, but in my view, the legally correct answer to the toilets conundrum for employers is this. The women's facilities in the workplace are for the use of women only, and trans-identifying males should be permitted to use either the gents or a single occupancy unisex toilet. That rule should be applied irrespective of whether the trans-identifying male in question has a gender recognition certificate, and that's a more complicated part of the argument. But if he doesn't, it seems to me very straightforward, but also irrespective of what, if any, treatment or surgery he may have had. That's my view. It's not without its vulnerabilities. In Croft and Royal Mail, as I'm sure you'll remember, the Court of Appeal ruled that a preoperative transection had lawfully been refused use of the women's toilets, but also suggested Oberter that at some stage of his transition, he would have to be treated as a woman. Unfortunately, the judgment doesn't then offer the unfortunate employer the slightest assistance in identifying the moment when that stage might be reached. That was in 2003. And by 2018, in Taylor, an ET in Birmingham felt able to treat it as self-evident that refusing a trans-identifying man use of the ladies was unlawful discrimination on grounds of gender reassignment, even in circumstances where, as is spelled out in terms in the judgment, he had had no surgery and had no intention of having any surgery. Taylor was a first instance judgment, and in my view, quite clearly wrong in that respect. But it was expensive for the employer and wasn't appealed. And there were a lot of surrounding facts. It seems, if taking the findings of the tribunal at face value, it seems that Taylor had suffered, as well as not being allowed to use or there being doubts about his use of ladies. He was found to have suffered quite a lot of quite unpleasant abuse and harassment. So that probably explains the employer's decision not to appeal it. So what's the right advice for an employer faced with this problem? How does it minimise the risks of being sued? And I'm talking here particularly about the toilets conundrum, because that is where a lot of the war is being fought. To my mind, the only truly safe option lies in the kinds of facilities we have here in Chambers. Single occupancy toilets, which may be badged as male and female, but for which, in truth, there's not very much problem if someone uses toilets badged as for the opposite sex. Anyway, provided they aim straight and raise the seat if appropriate. But supposing what you have in your workplace is separate halls of cubicles separated by flimsy partitions and one or two single occupancy accessible toilets, and suppose that for reasons of hostile space, you're just not in a position to remodel them. If you let a trans-identifying male use the ladies, your female staff may sue you, especially if you treat their complaints about the violation of their boundaries as a disciplinary matter. But if you offer him the use of the accessible toilets instead, he may sue and say that that's discrimination on grounds of gender reassignment. And there's certainly some evidence from the judgments of the employment tribunals in Taylor and that tribunals will, at least at first instance, some tribunals will be ready to accept those arguments. So that's not good news. I have nothing very comforting to say here. This is going to have to be fought out in the courts, and it's probably going to go all the way to appeal. There is no binding case law as yet. The remarks in Croft are both Delphic and Oberter. And whatever you do in this area, somebody is going to be furious with you and somebody's going to want to sue you. I think the best I can offer is to suggest that employers faced with the toilets or changing rooms problem should do what they think is right. That sounds trite, but if you may well end up in court, whatever you do, I would suggest that taking a decision that you can defend wholeheartedly is probably the best option. If nothing else, it will give you a more comfortable time under cross-examination. And finally, if an employer is struggling to form an intuition about what doing the right thing looks like, I would suggest that a good start might be not to tell its female staff how they ought to feel about sharing intimate spaces with a trans-identifying male, but to ask them how they do feel. Given the climate of fear that's been generated on these subjects in many, many workplaces up and down the country, it's probably a good idea to ask for that information anonymously. So that's all on my elephant traps. And back to Andrew for a minute.
Thank you very much, Naomi. Before we open to questions, and I've seen there are already some in the online question box. I had a question for you, and it was really about the Employment Appeal Tribunal's comments in Forstater on misgendering. Now, I noticed that in discussing the V case, you consistently referred to he and him. You may have noticed that I consistently referred to she and her, following the Employment Tribunal in that regard. Forstater in the EAT, they make it clear that a gender-critical belief doesn't lose its protection because it includes referring even to those with a gender recognition certificate by their pre-certificate sex. But the Appeal Tribunal did leave open the possibility that it could be, depending on circumstances, harassment of a trans person, or it could be harassment of someone else. My question for you is this, and it's not about whether you're right or I'm right. It's whether an employer would be permitted to introduce a policy requiring employees to refer to people by their preferred pronouns. What do you say? What way would the law treat that?
I'm going to give well, first of all, I'm going to say how delighted I am to be modelling civilised disagreement in this way. Andrew has used the language he's comfortable with. I've used the language I'm comfortable with, and nobody has felt the need to fall out over it. But the answer to your question is a classic lawyer dodge. It's very fact sensitive, and it's the lawyer dodge committed by Act Chowdhury in Forstater as well. Would an employer be permitted to introduce a policy requiring employees to refer to people by their preferred pronouns? Well, it depends who those people are and what the circumstances are. I've actually blogged quite extensively on this on the Legal Feminist blog and explored a number of different scenarios where I think in some cases the employer is entitled to say you've got to use your trans colleagues' preferred pronouns, or at least you've got to refrain from using accurate sex pronouns in his presence or in her presence. And other situations where it seems to me that the demand to use preferred pronouns is unreasonable. So I think it's difficult and it's fact sensitive, and I, for want of time, I think all I can say sensibly on that is two things. One, read my blogs because I explore it in detail. But two, the particular problem, the reductio in this situation is neopronouns. If somebody tells you that their pronouns are z, as in, and gives you a quick course of instruction on correct grammar to use with their neopronouns, I think that's an obviously unreasonable demand. You just can't ask people to jump through those hoops. But yes, the colleagues in the workplace, employers obviously have quite a lot of control. As far as referring to public figures, I think it would be very difficult for an employer to say you're not allowed to refer to, say, Eddie Izzard as him or get Bunce. I think that would be a serious incursion into the employee's freedom of speech.
And just since we're on pronouns very, very quickly, would you say that employers are entitled to require the use of preferred pronouns in emails, for example? And similarly, would you say that employers are entitled to refuse to allow someone who wanted to use preferred pronouns in an email signature to do so?
My answer to that is that I think it's a really bad idea for employers to try to require volunteering your pronouns with every email signature, because it's requiring a declaration. It's effectively requiring public assent to a belief system that not everyone will share, and some people will feel bitterly opposed to. Or even if you ask people, if you invite people to put their preferred pronouns on their email signatures, you're saying, do you want to sign up to this creed that some of your colleagues will despise you for not signing up to? It's not a good idea, don't go there. I do think, for exactly the same reasons, employers are entitled to refuse to allow their employees to declare their allegiance to a particular creed with every email. And it may be easier to see this in the context of a different kind of belief, because this is a belief that has managed to mainstream itself to a startling degree in a startlingly short time. But Christianity is a very, there are lots of Christians, several Christians in this room, it's a mainstream religion in this country. And yet you wouldn't expect your employer to require you to sign every email yours in Christ. And you certainly wouldn't, you certainly wouldn't expect them to require you to, but you wouldn't either expect them to commit you to sign every email yours in Christ, because unless you're working for a monastery or some religious organisation, simply not relevant. Your every contact doesn't need to know what you think about sex and gender, about religion. They don't need to know what your political allegiance is. They don't need to know what football team you support. There's a great deal of that. You don't bring your whole self to work. They don't need to know whether you're referring on your weekends. So no, not your pronouns, not your religious allegiance, and not either foxy or rabbity or whatever you are when you're referring, I would say.
Okay, well, now what I'm going to do is that I'm going to answer one of the questions that's been posed in the online Q&A, but I think for the benefit of the in the room, I better read it out first. So it's from Helen Robinson. And would you agree that following the EAT's decision in Forstater, a person who held and expressed the belief that sexual relationships between people of the same sex are sinful, wrong, or unhealthy would be protected under the Equality Act in the same way and to the same extent as a person who holds gender critical beliefs? So my answer to that question would be that it didn't even take the EAT's decision in Forstater for that person's belief to certainly qualify as a belief under worthy of protection under Section 10. I mean, that particular belief is a fundamental aspect of a number of different religious groups' beliefs. However, it's the point at which there could be there could be a problem is in the expression of the belief, of course. Now, if it is expressed outside of the workplace in a way which is calm and polite, then I think no matter how offensive I might find the expression of that belief, I wouldn't be entitled inside the workplace to demand that someone was disciplined or in some way taken to task for it. If it's expressed inside the workplace in a manner which is also polite discourse, then I think everything depends on context. If it is politely expressed to me every time I enter the room, then it is likely not to maintain the sort of protection, and it is likely to be something that I could claim was harassment of me. But if it is something that was expressed once, perhaps at some sort of slightly less formal work event in a civilized sort of way, then I think it probably is worthy of protection in the same way. But I think it's probably not something that follows from Forstater, because I think it's probably something that would already have been protected beforehand. Naomi, do you agree with that, or do we disagree about that politely as well?
No, I'm afraid I can't even politely disagree about that. I'm with you all the way.
Okay. So, Naomi, do you want to take some questions from the people that are in the room?
Yes. Any questions from people who are in the room?
I don't know if it's a question or comment. In terms of the whole toilet issue, so for a transgender woman who hasn't undergone the full sex change, using a female toilet, especially one which has got some competency. I'm just curious about the case for transgender women going to female prisons and whether the same issue has arose, because I'm assuming there must be a health and safety concern of there, perhaps the transgender woman perhaps attacking someone. So I'm just curious about prison case and whether that.
Yes, and there are. It's different law that applies in the prisons context because at that point, Schedule 3 and the single-sex exceptions come into play, and there was very, very as clear as possible permission to the authorities to run separate sex prisons and to keep all male people, however they identify, out of women's prisons, for, I would say, obvious good reason. But that's not prison policy. And there was a judicial review on it. There was FDJ and HMPPS. There was an attempt to JR the prison policy, which failed for reasons I can't now, off the top of my head, summarise. But I think possibly part of the problem with that JR was that the prisoner in question was trying to tread a very subtle line and say that she. The prisoner who was the claimant said that she wanted to exclude male prisoners who were sex offenders, but she didn't mind trans-identifying males otherwise. And that's actually quite a difficult position to argue coherently. Really, these decisions need to be made, I would say, if the arguments are to be made coherently, they need to be made on the basis of sex and sex is biological, and that's the answer. But that's a bit of a digression from the subject. Anyone else got anything? Yes.
I see that Alison Davis appealing.
Yes.
Naomi, can you repeat the question? Yeah.
Yes, I'm asked to comment on Alison Bailey's appeal, which was announced yesterday. She's appealing from the tribunal found in her favour in some respects in her claim of discrimination again by her chambers, but the much more complicated claim against Stonewall for aiding, abetting, procuring, etc., failed outright. No part of it succeeded, and I think it, to the best of my understanding, it failed for reasons to do with the precise analysis of what is procuring, aiding, inducing, etc. And my short answer is no. I can't tell you much more about it than that. I certainly can't venture an opinion on its prospects of success at this point because I haven't personally dived into that aspect of it. But yes, watch this space. It will be interesting. Anyone? Oh yes.
What is your view on the dangers of employers aligning themselves with associations like Stonewall, who may hold quite absolutist views with the aim of kind of use the word mainstream, which would be a good word, to sort of support a mainstream view?
I'm asked about my views. I'm asked to speak on my specialist subject, basically, which is my views on the dangers of organisations aligning themselves with organisations like Stonewall that promote a very particular view of some of these contentious issues. This is something that I've written on again at considerable length from Legal Feminist. I think my short answer as an employment lawyer would be don't outsource your HR function to pressure groups, because pressure groups have, and don't outsource your judgment to pressure groups because they have very specific agendas. And Stonewall in particular at the moment has a needle narrow focus really on the trans issue. And they still do a certain amount of work on sexuality, but it's almost all of their work and their impetus seems to be on the trans issue. If an organisation pays as much attention as Stonewall does to such a tiny proportion of its workforce to the exclusion of everybody else, then it's going to unbalance things horribly. You can't, I mean, you can't let Stonewall write your policies and a disability charity write your policies and a sex equality charity write your policies and a diabetes charity write your policies. So you've got to make up your own mind. Treat them maybe as a source of expertise with a pinch of a decent pinch of salt, but don't outsource your judgment. Yes.
Sorry, could I just
yes, sorry,
on that one? I think it's probably worth noting that in the Employment Tribunal findings in the Bailey case, the influence of Stonewall was very much overstated by in the claimant's case, and in fact, the interaction between the set of chambers and Stonewall seems to have been pretty limited, and seems not to have lived up to either the expectation of the set of chambers or indeed the expectation of Stonewall, both of whom were in it for what the other organisation could do for them, but neither of whom really seemed to have had much of a dialogue about anything. So while, as Naomi said, there's no harm in taking some advice from external organisations, and you wouldn't want to sign your whole HR policy over to them, I don't think in that case we were anywhere near, or anyone was anywhere near that sort of state of affairs. Sorry, Naomi, I interrupted you with the question.
And I think you're now going to take some of the questions from the chat, which I can't see, so you have the advantage of me.
Sure. There's a question from Dave Matton, which is, can you provide some more detail on the claims you see that women could bring against their employer if a trans woman is permitted to use changing rooms or toilets dedicated for the use of women? So Naomi, do you want to start with that?
Yes. And the obvious one may well be, depending on the circumstances, as long as there's not a trans-identifying woman wanting to use the gents. I think that's going to be fairly unlikely in most workplaces. If an employer permits a trans-identifying male to use the women's facilities are no longer single sex, whereas the men's facilities still are. So that's quite straightforward sex discrimination. Women don't have a private place away from men, but men have a private place away from women. There may well be harassment claims if women find the experience of using the toilet, especially dealing with menstruation in close proximity of male colleagues, that humiliating, intimidating, etc. The more fanciful possibilities include sexual harassment, but it's not wholly fanciful, because one of the tactics that women often use to get away from the harasser is to go to the toilet, where he's not allowed to go. But if your toilets at work are welcoming to everyone, especially if you're saying sex is self-identification, so you can't tell from looking at someone what sex they are, you have to take their word for it, then that makes it much more difficult for women to defend single-sex spaces across the board. So you do make life easier for those who would take advantage of that. So those are a few of the possibilities.
Well, I was just going to say, I'm not sure that I agree with all of your analysis, because surely if a trans man is permitted to use the gents' toilets and a trans woman is permitted to use the female toilets, there is no difference there. I mean, I think you suggested that the trans man wouldn't want to use the men's toilets. They're not that bad, I think, Naomi.
Not what I hear.
But
more seriously,
it's about the permission to use them rather than the number of times that they're used, surely, when it came to the analysis.
Yes, I agree that sex discrimination probably won't fly in a workplace that has both trans-identifying males who want to use the names and trans-identifying women who want to use theirs. I'm guessing that that's going to be, and given the numbers across the board, I'm guessing that that's going to be a pretty rare occurrence. In most circumstances where this rises, what you're going to see is the women's toilets made mixed sex and the men's toilets staying men's. And indeed, we do see, we've seen that quite often. already in labelling of toilets. Quite a lot of public spaces and workplaces have dealt with the problem of providing toilet facilities for everyone by leaving the urinals in the men's and leaving the men's badged as men's and turning a women's gender neutral. And that's the most obvious sex discrimination. Yes.
Sorry, in the claims that you listed, I didn't hear you say indirect sex discrimination or indirect religious discrimination.
You didn't.
And I thought that while some women may not object, it would put women at a particular disadvantage to be required to share the toilet with somebody that the facilities, and also indirect religious discrimination because those women who may require, not, for example, some women who wear a veil may be required not to show their hair and therefore not to adjust it in a room that might be accessed by men. So I would have thought that is actually quite a sort of quite a significant.
I agree, and that actually may be the biggest one for employers. Yes, that's probably the most obvious point. Thank you. Yes.
Yes, you spoke start the questions about the policy of employer introducing policy using only third pronouns or policy against using third pronouns. I suppose I ask at the risk of getting the same answer, but what if an employer would introduce a policy of using only gender neutral pronouns, only ever referring to one number as they, there?
Yes, yes, sorry, and I've been forgetting to repeat the question. And so I'll just jump back and repeat what Monica said, very helpfully pointing out that I missed the obvious point about making the women's toilets gender neutral is indirectly discriminatory. It's likely to be indirectly discriminatory against both women and religious minorities. And your point, which haven't I forgotten? Try again. Oh, yeah, yes. Is it okay for an employer to say, right, we're going to dodge this whole hornet's nest of pronouns and everyone is to be they, them in all circumstances? Interesting. And you could try it. I think, off the top of my, I haven't thought about this before. I would have said I thought about most aspects of pronouns, but I haven't thought about this. I think that would be quite hard to attack. You might have forced speech issues about it. I would be, personally, I would be happy with it. I think a lot of people would feel that they were being made to participate in an interview that gave some sort of legitimacy or assent to a creed that they didn't believe in. But it's not so clear to me that that would amount to that sort of assent. Because it's so clear that an employer could just be saying, a plague on both your houses, I don't want to hear this. So I think that's an interesting idea. I don't think it's very practical. I don't think, people forget, you can't enforce it, but in theory it's interesting. Sorry, Andrew.
No, I think that's a great idea, and I shall recommend it to the Chamber's Management Committee and we can implement it by next week. There's another question from online I wanted to pose. It's from Melanie Field, and it relates, Naomi, to the longer answer that you gave about the toilets. And what she says is, surely your analysis only holds when the trans person doesn't have a GRC. So if I answer first briefly, I think that that's right. And if someone does hold a gender recognition certificate, given that the 2004 Act says where a full gender recognition certificate is issued, the person's gender becomes for all purposes the acquired gender, then in the workplace, the provision of toilet facilities would need to include, female facilities would need to include provision for trans women. It could be different where the provision is something which is provided as a service, but that's taking us away from to employment law, to discrimination law more generally. Would you agree with me, Naomi?
I wouldn't, no. It's a terribly interesting question, which is not surprising. Thank you, Melanie. Last time you and I discussed this, I was of the view that a gender recognition certificate made all the difference to the legal analysis. And sex in the Equality Act meant biological sex in the first place, but also sex as modified by the operation of Section 9 of the Gender Recognition Act. And that would mean, that would mean that somebody with a gender recognition certificate, even if a trans-identifying male with a gender recognition certificate, even if he was taking no steps whatsoever to pass, even if he still retained a beard, even if he had no treatment and made no attempt to wear female clothes, but had a gender recognition certificate, and was certainly, if the proposed reforms go through in Scotland or here, that will be something that can easily happen. But in any event, my view when we last spoke was that a gender recognition certificate made all the difference to the legal analysis under the Equality Act. And that once you got a gender recognition certificate, as far as the Equality Act was concerned, you were a woman if you were a trans-identifying male. I don't any longer think that. I think once you delve into the complexities of all the different situations in which the Equality Act refers to sex, it becomes cumulatively clearer and clearer that it must be talking about biological sex. There is so much of the Equality Act that refers to pregnancy and lactation and breastfeeding and you know, things that only women do, things for which you have to be a woman, an actual biological woman, not by operation of a certificate. So I don't any longer think that the Gender Recognition Act changes your sex for purposes of the Equality Act. And that's the thing I alluded to earlier. I think this is extremely difficult and interesting. And I think we could spend the rest of the evening discussing it. But my current view is that Gender Recognition Act is made a difference. What we've got to do in the workplace is provide single-sex facilities, and that means single-sex facilities literally.
But Naomi, aren't you having to read in the words "except for the Equality Act" after the words "for all purposes" in the 2004 Gender Recognition Act?
I think probably I'm having to read the word sex. I don't think it's about reading in words to the Gender Recognition Act so much as reading the word sex in the Equality Act in a particular way. But that particular way, I think, makes much better sense. And I agree, and I absolutely agree with this problem. And the obvious argument against my position is Section 9 is perfectly clear. It says for all purposes, except in the circumstances, except where modified by statute. And all you've got to do is read the words and keep reading. It's obvious that it modifies sex in all the other places where sex is referred to. But I think the practical implications of that and the way that the whole scheme of the Equality Act works simply makes that untenable. So I think you've got to read sex to mean sex in the Equality Act and in quite a lot of other legislation as well. But that's an argument for another day. I'm conscious of the time and the fact that there are a lot of people in this room who were promised a drink at 7 o'clock and it's now 7:30. So I think we probably better stop, haven't we?
Yes. Thank you all for coming. Thank you for those who are attending online. Thank you, Naomi. And I will perhaps be able to see some people in person at some point.
Thank you, Andrew, and thank you everyone for coming.